Hey, everybody out there. Today we have more on the Greenberg case, and with us is the co-counsel for the Greenberg family, Will Trask, and he's going to bring us up to date on two lawsuits that the Greenberg family has brought against officials that look like they've been containing this case for the last 12 years. The daughter was found dead of 20 stab wounds 12 years ago, and despite repeated and intense attempts to get officials to take another look at the case, they've always said that it is a suicide and nothing more to investigate. So, Will, tell us about the two cases. The first one is an attempt that you're bringing to have the official finding of the medical examiner, Marlon Osborne, overturned from suicide to either homicide or, at the very least, undetermined. The second case is charging a number of officials involved in the investigation with a conspiracy to cover up a murder, I believe. So let's go to the first case first. Where does that stand, the attempt to get the medical examiner's conclusion of suicide overturned?
So the first case is currently on appeal in our intermediate appellate court. I don't know how much background you need under the first case. I know there were a number of, moving parts.
Well,
in that case,
what's interesting about the case is Marlon Osborne, the medical examiner who did the autopsy, officially did declare it a homicide. Then that changed. Tell us about that.
Right. So in that first case, Ellen died January 26, 2011. Mr. Osborne, the pathologist, when he conducted his autopsy the next morning, discovered that she'd been stabbed 20 times. 10 of those stab wounds from behind, which had gone unnoticed by the investigators on the scene. So although her death was initially treated as a suicide by the on-scene investigators who didn't notice how brutally she'd been stabbed, Mr. Osborne the next morning, Dr. Osborne, when he conducted the autopsy, he found all the additional stab wounds. He found bruises on her body that raised a number of questions for him, and he ultimately declared it that morning a homicide. Unfortunately, by the time he had done that, the apartment where Ellen had been living and had died had already been cleaned up by a crime scene cleaning service, so that when investigators received his finding of homicide, obtained a warrant to go and search the apartment, and arrived to collect evidence, the place had been scoured top to bottom.
So there was no way of recovering any evidence that might have been at the scene.
That's right. So after that, Larry, several weeks passed, during which time we've since learned that Dr. Osborne was encouraged to change his finding from homicide to suicide and effectively putting an end to the case.
Encouraged by whom?
So that gets into the second lawsuit.
Right.
So by way of background, in the first lawsuit, the family didn't accept Dr. Osborne's finding of suicide based on the information that they knew at the time. They enlisted the help of expert pathologists to review the facts of the case. They all unanimously concluded that this was not a suicide. And ultimately, we approached the city and requested that they relook at the case and reconsider changing the manner of death from suicide to something else so that an investigation could be done. When those requests weren't fruitful, we ultimately filed a lawsuit. And during the process of discovery in that lawsuit, where we requested from the city that they provide us with any evidence that would support the initial change to suicide or justify their reluctance to change it, pursuant to our lawsuit, we got a couple of really important pieces of evidence that fed into the second suit. The first being Dr. Osborne testified that in the spring of 2011, he was called into a meeting that was attended by members of the police force, the district attorney's office, and the medical examiner's office. And at that meeting was provided with evidence that the apartment was entered, we back up, when the apartment was entered, when the door was broken down, there was a disinterested third-party witness who was there that saw the door was locked, saw it being open and was there when Ellen's body was discovered. Although Dr. Osborne had been suspicious of the locked door theory from the start and had said he was aware of a number of ways that the door lock could have been manipulated and didn't take it into consideration in his original homicide finding, he was ultimately convinced when he was told by members of the police or the district attorney's office that there was been a witness there.
Excuse me, that witness was the fiance, Sam Goldberg, correct?
Wrong. So the fiance, Sam Goldberg, is who had always been identified as the person who broke down the door and entered the apartment. The witness, according to the police, was Phil Hanton, the security guard who worked the front desk at the apartment complex. So Dr. Osborne testified that he was aware of the statements obtained by police regarding Mr. Goldberg entering a locked apartment, but Dr. Osborne said he was always a little suspicious of that, didn't give it much weight. He wanted to look at the medical evidence instead. And it was when police confronted Dr. Osborne with evidence that the front desk clerk, Mr. Hanton, had gone up with Mr. Goldberg and was there and witnessed the door being broken in and Ellen being discovered. That was what ultimately convinced Dr. Osborne that, more likely than not, this ought to be changed to a suicide.
Okay, now the story was that Sam Goldberg's story, the fiance's story, was that he broke down the door with the concierge, correct? Did they break it down together, or did the concierge break it down?
So I don't know what Sam Goldberg's story was. They've never released to us any statements that he gave to the police. That part of the file has been withheld from us. We do know that in the reports from the medical examiner's office, the final report after this meeting with police investigators, that Mr. Osborne updated his report and claimed in there that Mr. Hanton had been with Mr. Goldberg when he kicked down the door. And it's our belief that information came from the police and the DA. We don't know where they got that from.
Okay, wasn't it later proven by a statement from Mr. Hanson himself that he never accompanied Sam Goldberg, the fiance, up to the apartment to enter it?
That's right, Larry. So we did finally speak with Mr. Hanton. Mr. Hanton was adamant that he didn't accompany Mr. Goldberg upstairs. He wasn't there. He didn't see the door being kicked in or anything else. And after fighting with the city for almost a year, we were ultimately able to obtain a copy of the surveillance video that of the building lobby and the elevator bank downstairs, which show that Mr. Hanton did not go up the elevator did not accompany Mr. Goldberg up the elevator, and he only later went up with emergency responders after 911 had already been called.
Now, were those facts brought to Mr. Osborne, the medical examiner, and also to the other investigators?
So those facts were obtained after Mr. Osborne was deposed, although he did admit during his deposition that if there was, in fact, evidence that these representations by the police that Mr. Goldberg had been accompanied by a witness, had there been evidence to disprove that or to call that into question, then he would be inclined to change his suicide finding back to homicide or to something else. I don't know whether these new facts have been shared with him by his counsel or not, but I imagine he's been made aware of it at this point.
So he said that he would be inclined to change it from suicide either to homicide or undetermined, but he didn't do that. Why not?
I don't have an answer for you. It's our position that, given his testimony, that's what he would do if that's what the evidence showed, that he ought to do it. And I don't know at this point why that hasn't been done.
Now, in terms of roadblocks that are being set up to your team, aren't they saying that legally the medical examiner's finding cannot be overturned by outside parties?
That's right. So that's the genesis of the current appeal. So After Dr. Osborne testified at his deposition, we also took the deposition of another city pathologist, who ultimately concluded, and I can get into it if you like, but ultimately concluded that Ellen was already dead when she was stabbed, and therefore suicide is an impossibility.
That was Lindsay Emery.
That's correct. That's
Okay.
correct. And having those two pieces of evidence, Dr. Osborne's admissions and Dr. Emery's testimony, we felt pretty strongly that a judge would agree with us and compel the medical examiner to change the manner of death. But on the eve of trial, the city filed an appeal, sort of an unusual interlocutory appeal, the sort that aren't typically granted on the eve of trial. This one was granted. It's gone up to the appellate court, and the argument of the city is essentially that the court has no authority to compel them to do anything, to change their earlier determination, even if it's obviously wrong. And also, secondarily, that the family of Ellen Greenberg don't have the authority to ask the court to do so. And those are discrete legal issues that they've raised on appeal, and we're waiting for a decision from the court.
What's your counter argument to their declaring that the city has no authority?
Well, the case law. I mean, my counter argument would be that the cases going back decades in Pennsylvania are clear that if there's evidence that the discretionary decision of a city or state official is arbitrary, capricious, or predicated on fraud, then the court absolutely has every right to step in and force a change. And we live in a free country where the courts have, oversight, and our elected officials, appointed officials, aren't dictators. They have responsibility.
So the appeal is before what court now?
The Commonwealth Court.
And if you lose there, what happens?
I imagine, regardless of the outcome of the Commonwealth Court appeal, requests will be made to the Pennsylvania Supreme Court to rule on the issue. So if we lose, I imagine we'll take an appeal, and if we win, my guess is the city will take an appeal. Well, they'll request an appeal. I mean, it would be up to the Supreme Court whether they would agree to accept it.
Now, how long has this appeal been pending?
I believe they filed for the appeal in December of 2021.
So it's been hanging there for quite a while with no decision.
It has been. I mean, there was the spring and I guess early summer when the issues were briefed, and it was argued, I guess, late summer or early fall of last year, and then we've been awaiting now for a few months a decision now that it's been completely briefed and argued.
Is that usual, that kind of a delay?
I'd say it's not unusual, particularly given COVID and the setbacks that the entire court system has had to endure. I don't think it's unusual that it's taken this much time.
Okay, let's go to the second case now, unless there's something you want to add to this.
No, that's fine.
Okay, so the second case, you're actually accusing a number of the investigators of a conspiracy to cover up a homicide. That's a criminal charge, isn't it?
Yeah. So in the discovery that we obtained in the first case, the evidence that Dr. Osborne was encouraged to change the manner of death from homicide to suicide, despite the overwhelming evidence to the contrary, evidence that the police investigators were unable to conduct an investigation, given the fact that the crime scene was cleaned before any investigation was able to take place. Evidence that Dr. Emery, the city's own neuropathologist, has concluded, based on her findings, that Ellen would have been dead before she was stabbed and couldn't have stabbed herself, meaning suicide is an impossibility. And the continuing efforts of the city to ignore that evidence, withhold other evidence, and refuse to reconsider this case suggests to us that there has been a concerted effort on the part of members of the city investigative apparatus, the police, the district attorney's office, and the medical examiner's office, who all participated in that in that meeting to convince Dr. Osborne to change his manner of death, that's it. It was a decision made by those folks to change it erroneously, falsely, deliberately from suicide, from homicide to suicide, with the result being no investigation.
So that suit then would conclude on your part that they knew darn well that the facts did not add up to declaring it a suicide, and they purposely, intentionally, and actively ignored that to cover up a homicide.
That's right. For example, the video evidence, the surveillance videotape. Although it took us a very long time to extricate that from the city had it, and there's evidence in the file, evidence that's been produced by the city to the family, that they had it back then and reviewed it back then. So the claim to Dr. Osborne at that meeting that Mr. Goldberg had been accompanied to the door and there was a witness there who watched him kick it in, we know now, based on the evidence that we obtained in the first suit, that they knew at the time they represented that to Dr. Osborne, that just simply wasn't true. Same thing with Dr. Emery's case. I mean, here we have definitive evidence that this isn't a suicide, and notwithstanding that, there's been a concerted effort among these city officials to keep that under wraps and refusal to change the manner of death in the case.
Now, the roadblock you're running into with this second suit is that they, according to the counterclaim there, that they have these officials have absolute immunity for their actions that they take in their official capacity. They're immune to any kind of charge that you're bringing. Explain that for us.
Right. So under many circumstances, government officials are immune, can't be sued, can't be held accountable for decisions they make pursuant to their public offices.
Right.
And it's an important policy and one that ought to be upheld and protected for people who are just doing their jobs. People make mistakes and can't, the government coffers would be bled dry if these officials doing their best efforts, working in good faith just to do their jobs, were sued for every little mistake. Government immunity, absolute immunity, does not apply to criminal conduct by public officials. And here we're alleging essentially that these officials were accomplices after the fact to a murder and deliberately covering up the fact of a murder is a criminal charge in this state, and therefore not within the scope, the gambit of a public official's responsibility. If you break the law, then you're not doing your job, and therefore not subject to the immunities afforded to those who are.
But this is a civil suit, correct? Not a criminal suit. It's a tort.
That's right.
So does that standard apply then, since it's not a criminal case?
The distinction is, although this is a civil suit, the conduct alleged rises to the level of being wanton, willful, deliberate, and criminal. Therefore, it falls outside the scope of a public official's responsibility. In other words, immunity only applies to public officials who are working within the scope of their employment, who are doing their jobs. And if they make mistakes pursuant to that effort, then they can be immune. However, if they break the law, that's not why they're there. Nobody is put into public office to commit crimes. That is outside the scope of their job and therefore outside the umbrella of the immunity.
Well, Will, my question would be, and this is a layman's question since I don't understand the law as extensively as you do, why not just bring it as a criminal case to begin with?
Well, we have to find a charging authority willing to do it. I'm not authorized to bring a criminal case. We would need a district attorney or an attorney general to file criminal charges. And so far, there doesn't seem to be one willing to do that.
Have you approached any of them to do that?
No. We have only recently, in the first lawsuit, which again was limited to the issue of changing the death certificate so that further investigation could be conducted. We've only just uncovered this evidence. And whether or not in pursuit of the second case, additional evidence is uncovered that does support criminal charges, well, then, that'll be a question, I think, down the road. But, at this point, we just want to bring these people into the light and hold them accountable for, the harm that they've done to the Greenberg family.
Reading between the lines here, if I'm interpreting it correctly, you wouldn't even bring it before a charging agent now because of their past behavior, where they didn't want to know anything about this. It was a clear-cut suicide from the beginning. Josh Shapiro, who was Attorney General at the time, was twice approached by the Greenbergs to take another look at the case. Twice he said clear-cut suicide. Up and down the line, there's been this resistance. So therefore, probably at this point, you figure it would be useless, futile, to even ask a district attorney or a prosecutor to bring a criminal charge. Am I interpreting that correctly?
Well, I think certainly. Well, I guess the short answer would be yeah. I don't think that, given what we know to date and given all the intricacies of the case, that a district attorney would be interested in this, and it frankly would be in the jurisdiction of the Philadelphia district attorney, who's already got a conflict and can't really be involved in this case as is.
We should review that a little bit. Josh Shapiro, before he became governor, he was the Attorney General of Pennsylvania, and some evidence came to light that there were what he called a possible conflict of interest that he says really wasn't. But because people allege that there was a conflict of interest, he kicked it back to the district attorney's office, which kicked it over to the Chester County DA, where the case rests now officially, correct?
That's right. Yeah. So it's been a little bit of a hot potato from the start. And so Mr. Krasner has a conflict of interest.
The DA
in Philadelphia.
Okay.
So when the family initially asked him to review this case again, a number of years afterwards, he properly, identified the conflict of interest and asked instead that the Attorney General's office look at it.
Which was Mr. Shapiro at the time.
Which at the time was Mr. Shapiro. Then more recently, Mr. Shapiro's office identified, the potential appearance of a conflict of interest within his office, and given an appearance of a conflict of interest, it's absolutely appropriate to take no further action on the case and refer it out. So he sent it back to Mr. Krasner's office, who then has sent it to Chester County because with Mr. Shapiro conflicted and Mr. Krasner conflicted, they needed to find someone else. And it was Mr. Krasner's prerogative to pick someone else, and he has done so. So that's where it is now. But this is separate from the lawsuit.
Yeah.
The lawsuit's asking a judge to compel a new look at this case. This other issue of being bounced around between state and county authorities is a separate issue that kind of precedes the lawsuit from the parents asking initially the DA's office to look at it.
What was the appearance of a possible potential conflict of interest of Mr. Shapiro?
I don't know. That wasn't ever shared.
Okay. But now it's in the hands of the Chester County DA. It's been in her hands for at least 2-3 months, and no action from that office yet, correct?
No. I mean, we're hopeful that they're looking at this closely and that they come to the right decision, but nothing yet.
Now that Mr. Shapiro is the governor of Pennsylvania, do you expect any effects from his higher office now that would be favorable or unfavorable or just neutral to the case?
That in part probably depends on whatever the underlying appearance of a conflict may have been. I don't know what it was and whether it was his office that was conflicted or him personally. So I don't know, whether it would be appropriate for him to have any opinion as to the outcome of this case.
So he couldn't be approached then to take another look. Would he have more powers as governor to reopen the case?
It's a great question and one that I hadn't actually considered. Typically, it's not the province of the governor to get into the minutia of, a little case bouncing around the counties, and he certainly wouldn't be appropriate to order someone to do something or not do something. Um, from all appearances, he's made the decision, or his office made the decision when he was Attorney General, that it wasn't appropriate for him or that office to be involved, and they sent it back to Philadelphia. And so my assumption is he's not going to be involved, given that he's already flagged the issue. And we'll leave it up to the Chester County District Attorney's Office for now, and for the Court of Common Pleas and the Commonwealth Court to make the decision.
Of course, he didn't kick it over to the district attorney's office until 4 years after the case was first brought to him, and he only kicked it out of his office after these appearances of possible conflicts of interest were raised. Correct? So he had it for 4 years without dismissing himself from the case.
That's true. The timeline's true. But again, I don't know what the alleged conflict or appearance of conflict is and how it may have been brought to his attention. So I can't really opine as to whether that timeline is problematic or perfectly appropriate.
Yeah, from what I understand, he had some social ties to people, relatives that were familiar with Josh Shapiro at the time. I mean, that's just a vague summary of it, but it had to do with that. But let me ask you, Will, and I know you have to measure your words carefully here, but do you have any suspicions or inklings or indications of why there's been so much resistance to really examining this case professionally and thoroughly and competently for the past 12 years?
Well, that is in part the impetus for the second lawsuit, is getting an answer to that question. And I think among the questions raised within that lawsuit are, is someone trying to cover the fact that the initial homicide investigation was botched from the start? Was there an acknowledgement that there would never be a conviction, and rather than have one more unsolved murder on the books in Philadelphia, this would be an easy case to just make it go away? And was that the reason? Was that why it was done?
So
I don't know.
So you're convinced that at the very least this was a cover-up, but we can't determine yet the reasons why. It might have been simply to cover up their incompetence, correct? It might simply have been that.
Correct.
But it was a cover-up.
That's right.
Now, could it be a more sinister motive in somebody containing this because they were protecting somebody for some reason?
Well, look, anything's possible. I mean, at this point, we're just going to follow the facts where they lead and see what happens. I mean, in the first suit, we didn't anticipate that the city's own neuropathologist, before we'd even filed, had looked at this specimen, concluded that she was already dead when she was stabbed, shared that with her supervisor, and all that had been concealed from us. So, a lot of this stuff comes out in discovery during the lawsuit, and we're just going to have to pursue the suit and follow the facts where they lead us.
Would there have been just one person who would decide that this was going to be covered up, or would be a number of people involved? I mean, how would this have come about, a cover-up, since so many officials and so many important offices were involved in this alleged investigation? Who would have been in a position to decide that, to cover it up?
Yeah, I don't think it would be appropriate for me to speculate, because there are too many different possibilities. And, I don't want to point fingers at any particular official or official office and suggest that, well, if I was going to cover up a murder in Philadelphia, this is how I would do it. Because we just don't know. And, and again, it could be as simple as a botched investigation that they wanted to sweep under the rug, and, it was kept at relatively low levels. I mean, who knows? That's what I think is going to come out of the discovery in this case.
Yeah, the botching started right away when they allowed a professional crime scene cleanup crew to come in and clean the apartment before the police did any forensics, correct?
That's right.
All right. And secondly, they allowed the lawyer uncle of the fiance, namely Mr. Schwartzman, to go in and remove electronic devices, cell phones and laptops from the apartment before the police were able to examine them, correct?
Correct.
I mean, how outlandish was that?
Well, based on discussions I've had with law enforcement, former law enforcement, it's very, very unusual. That's not the sort of thing that you would expect from a homicide investigation, and that's the sort of mistake that is egregious enough that it would warrant a cover-up potentially.
How was Mr. Schwartzman allowed into the apartment? How did that come about?
So all we know from the building manager who oversaw operations at the apartment complex, and she has given a sworn declaration that she was contacted by the fiance's family, who asked that they be allowed into the apartment to get some items of clothing for the fiance in anticipation of Ellen's funeral. And she thought it was an unusual request given that there was an active crime scene at the apartment. So she contacted the authorities, the police, and conveyed the request from the family. And they told her, no, that's fine. They can go in. No big deal. It's not a crime scene. We've concluded that this was a suicide. It's not our problem anymore. It was the building manager who raised the issue with police that, well, what's the condition of the apartment? Is it really appropriate to be letting people in there? And the police said, well, cleanup, that's not our bailiwick. You're going to have to arrange for that separately. But I can give you the name of a service that that's been used that cleans crime scenes. But that's going to be, payment's going to be the responsibility of the family. That's not a police issue. So she took the number. She shared that with the family. The family agreed to foot the bill, and the crime scene cleaning service was arranged to come in that morning and clean up the apartment. And then afterwards, members of the family came in and they got clothes for the funeral, and also grabbed laptops and phones from the apartment before they left.
Well, another problem here, the way I understand it, is getting access to the police records, the statements they might have taken from the fiance and other people, and that apparently has been denied to you. First of all, is that correct? And how can they do that?
So that is correct. We have been given the medical examiner's records, although we don't know if we have complete medical examiner's records. And we have accumulated over the years, the family has accumulated over the years through discussions with the DA's office and others, a smattering of records here and there. And that's the universe of documents we've been given. We've never been provided with the full police file. We don't have investigative reports, homicide reports, any reports of interviews done with witnesses or anything of that nature.
And on what basis are they withholding those?
Well, so they've never officially objected to producing those records. I think in part because doing so would put the question in front of a judge. I suspect the legal basis for withholding it, the legal basis that city and authorities typically use when withholding this sort of information, is the Criminal History Record Information Act, which precludes from dissemination any records of an investigation, any police investigative records. Now,
into a criminal case.
That's correct. So obviously our position would be this isn't a criminal case according to them. This is a suicide. So there would be no reason why that law precludes them from turning it over. But that case, because we have what we need in the first case, it hasn't been pursued in that case. And the second case is only just getting started. So I think that that's probably an issue that's going to be teed up before too long. And the fight over those records will be, coming shortly.
For outside observers who don't know the law extensively, it seems obvious to them that this was an obvious cover-up. And the big question is, why? And I know you can't speculate on that, but is this one of the more unusual cases that you've come across in Pennsylvania in terms of a sloppy, incomplete, incompetent investigation and authorities for 12 years now being totally uncooperative in really examining the case properly? Is this an extreme example of this kind of thing in your knowledge?
It is. It is extreme. And I don't understand why, rather than agree to reopen the case and investigate it years ago, there have been such lengths taken to avoid that outcome. Why not? I mean, we wouldn't be in a lawsuit now if they had agreed years ago, you know what, fine, we'll change it to undetermined and we'll conduct an investigation. At that point, we would have had no basis to file a lawsuit. They could have mooted the lawsuit when we filed it if they'd done that, but instead they dug in their heels and they've raised these, obscure legal objections, claiming that the court has no authority to order them to do anything, and that's where it stands. And I don't know why. I don't know why.
Well, if you lose both these suits and any appeals that stem from them, where do you go from there?
It's a good question. I hadn't thought about it because I don't plan to lose either of these suits. So, I guess I'll have to think about that when it becomes relevant. But we're right on the law. We're right on the facts. The experts, all of the experts, including the experts employed by the city, their scientific conclusions support the fact that Ellen didn't kill herself. And given that those are the facts, there's no reason for the death certificate to continue to reflect otherwise. And the law's on our side, and I don't plan to lose.
Attorney Will Trask, co-counsel in the case of the death of Ellen Greenberg, thanks very much for being with us.
Thanks, Larry. I appreciate it.